Okay. All right, welcome everybody to the session Navigating Rules and Regulation, an update from federal and state leaders from the Pennsylvania Hemp Summit. We're going to dive into this right away. We have a fantastic panel and not a lot of time, so we're going to get started right after this brief video from our sponsors.
The same air products gases that have been used safely and successfully for over 60 years in the food and pharmaceutical industries can also be used by hemp processors to improve the quality and yield of their product. Gases such as ultra-cold liquid nitrogen and related equipment, like our tunnel freezers, can help make your production process more efficient. Flash freezing your harvest prior to storage prevents mold and locks in the plant's rich chemical content. During the grinding process, adding liquid nitrogen to the conveyor can eliminate oil stickiness that causes clogging and subsequent downtime. And when cold extracting, liquid nitrogen can be more efficient removing the desired oils, all resulting in improved quality and yield. Talk to us and work with our application experts to review your process and identify opportunities. We have a state-of-the-art applications lab to test your product, or we can visit your site for field testing. Let's work together to improve your hemp production process. Visit our website for more information.
Okay, great. I do believe that very shortly you'll see a brief poll come up that we would appreciate you participating in. As just some general housekeeping, we ask that you remain muted through the duration of the broadcast unless we hopefully have time for some Q&A. If you do have questions, there is a Q&A button at the bottom of your screen.
Yes, sir.
And your questions in there. So like I said, we have a lot to get to today. We have this really fantastic panel. How we're going to do this is each panelist is going to have about 5 minutes or so to give a brief presentation, and then we're going to go into questions. So just so you're aware of who we have here, we have Fred Strathmeyer, the Deputy Secretary of Plant Industry and Consumer Protection from the Pennsylvania Department of Ag. We have Zach Gihorski, the Associate Director of Public Policy for NASDA, which is the National Association of State Departments of Agriculture. Bill Richmond, who's the Chief of the USDA Hemp Program. Sean Mitchel, the Chief Intergovernmental Affairs from the Drug Enforcement Administration within the Department of Justice. And Ed Messina, the Deputy Office Director for Pesticide Programs with EPA. So with that, we're going to kick it off with Fred Strathmeyer from the Department of Ag.
Thanks, Erica. Appreciate it very much. I'm going to take time to share with you some of the past history and also then some of the new nuances for the coming season. And then at that point, as Erica said, we'll move on, and I'll let my colleagues from the federal government take over as well. Okay, so let's do this again. I apologize. I'll share my screen with you. And we'll get started. And I apologize.
Fred, we can see your screen if you just want to go ahead and click from beginning.
Okay. And
Great.
there we go. Okay, thank you. As I said, I'm just going to go through a few slides with you, little bit of history from where we started and where we are today. Our program started with the 2014 Farm Bill, the research part of it. In July of 2016, the governor signed the Industrial Hemp Research Act. And then we moved on to the program in 2017. In 2019, we were following the 2018 Farm Bill, which gave a little more latitude to the program. And with that, one specific thing that we did in the state of Pennsylvania is we opened the amount of acres to unlimited. And that was a significant thing. And you'll see that in some slides down later on that indicate how much the program grew from the 2018 to the 2019 season. In 2019, a significant piece was the interim final rule, which will be discussed a little bit later. But we submitted a proposal to USDA for a program here in Pennsylvania. That submission happened. We were approved, and at that point, we started to move on. One of the other pieces of significance here in the state of Pennsylvania was that in 2017, we had passed the Controlled Plants and Noxious Weed Act. That allowed us to put the hemp program under that particular act. And the significance of that is that we didn't have to go back to the legislature to rewrite a new hemp type of legislation. And so it gave us the opportunity to keep moving forward in the state of Pennsylvania. As I said to you, from 17 to 2020, we've seen significant participation here in the state. One of the things that I'll tell you right now is that at this point, we don't have the exact number of acres, but registered, there were around 3,000 acres and about 510 permits were given out. Now the significance I'll leave here is that we changed to making the permit apply to the site. In 2019, it was simply the permit was permitted by the individual or the company. So that's where you see a little bit of difference here between 19 and 20. So new for 2020, we also started to permit our processors. This was a significant thing for us to do. It was a request that we had received in conversations with our steering committee and with others around the state, the significance of finding and being able to have legitimate types of processing permits or processing facilities here in the state. You can again see the breakdown in 2020 of the 510 growing permits. Significantly more product was being grown for CBD. There is a map at this particular site link that we have a map of all the permitted processing and growing operations in the state. For one of the pieces that we are going to change in 2021 is that we've been, again, in conversation with the industry, and we're going to begin to try to limit a little bit of that information that we actually carry on our website. That's been something that has been a concern of some of our permittees. So we're making an adjustment this year. This slide shows you just as simply as that, again, hemp is a regulated commodity and you will be required to have a permit here. Nothing new there. Every property where hemp is grown or processed will require a permit. Key there is that applicants are required to have FBI background. Don't know if that's going to change or not, but we'll find that out later. And we have established some location requirements in conjunction with, as many of you know, we have the medical marijuana program, and so we've been working with them, the Department of Health, to make sure that program and our program, we have synergy between the programs. Again, this slide just shows you some of the minimum requirements around those locations and restrictions. Many of these things came from requests through the industry, and we implemented them for the 2020 season. A later slide, I'll show you that some of these things we've changed going forward. This particular slide is showing you that about the contiguous planting of a single variety and how we must work on the sampling and what that looks like moving forward. One of the areas of great concern in the state of Pennsylvania and across the country has been this 15 days for sampling. The THC level, again, this is something that going forward, just do understand that we do not control that here at the state. USDA does not control that. That is something that Congress would have to change. I think this is an area that many times is misunderstood. And even though many of you wish this to be changed, it will take legislation at the federal level to make that happen. We're looking at in 2020, like I said, we're looking at the interim rule now, working with it and using it. But we have seen a delay in this enforcement that has been extended to October 31st of 2021. We're also looking at the final rule that we hope comes early next year. But again, you'll hear more on that coming later. Laboratory issues, certainly here in the state, we are trying to get some continuity around our laboratories. So we're anxious to see where DEA is going to stand on laboratory registrations moving forward. In July 2020, we established for the first time the hemp sampling agents. It was a training program that we used to certify individuals. They were private contractors, laboratory employees, agricultural consultants, and that type of person. We ended up with 59 agents across the state. We found it to be a very good new thing that we implemented this past year. We will be doing it again next year with potentially some changes moving forward in that program. Again, this slide shows you about the sampling agents, and this link again is a way to look at if you're interested in becoming a sampling agent. Just remember that you can't be employed by or financially invested in any hemp operation. And that type of information is there at that link. So updates. So if you remember, I talked to you a little bit about the locations and the criteria around those locations. We have changed the outdoor growers must plant a minimum of 150 plants. That was previously a quarter acre and 300 plants. So we've listened to the industry and we've made some adjustment there. Indoor growers must maintain a minimum of 1,000. That used to be 2,200 plants. So we are taking the information that we're getting from the industry and we're trying to work with them. We're here to make our industry successful in the state of Pennsylvania, and so we're happy to make these changes. Another piece that we've removed is this requirement for signage. It is something still that we highly recommend, but it's not going to be a requirement going forward. This simply allows our growers to be identified sometimes by local law enforcement, and we encourage that kind of partnership on the local level. This year we have updated, and we will have a research permit for institutions of higher education, research institutions. This is to enable research to be done. As we all know, there's much more research that needs done. It allows for that smaller scale operation to be able to do something without getting into the commercial activities. Another significant change that is going to be applied for the 2021 season is that if you get this laboratory result back at 0.3 or less, which is the compliance level, permittees will be able to move crops once they receive this certificate of analysis. It is an area that we've heard from our growers. This will eliminate some of the delays at the farm level moving forward, and we're happy to have implemented that. As I said, we're going to update the hemp sampling training, additional requirements for laboratories conducting testing of compliance sampling. We're trying to streamline this laboratory information to provide consistency for our growers. Essentially, what we've heard is that sometimes it's hard to read these laboratory results. And so we're hoping to work with our laboratories here in the state to create a more streamlined and more user-friendly type of result coming back to our growers. So again, unless changed by USDA in the final rule, a hemp lot is still a contiguous planting of a single variety of hemp. Testing of every hemp lot the 15 days before harvest by a third-party sampling agent. The THC level above 0.5% total THC shall constitute a negligent violation. All these things right now, they're all part of our general permit and will continue to be unless things are changed. We did want to let you know that we certainly are reaching out and working with our federal partners. And we had made, when asked for the second round of comments to USDA, these are some of the comments that we passed on to them. We did talk about recommending and extending the sample time to 30 days. Don't know where we're going to end up, but again, we just wanted to let you know, and I'm letting you know that these are some of the highlights of things that we have provided to USDA to consider moving forward. Again, do not want to take time to read all this to you, but looking at, and I want to tell you that the general permit we worked with and are very happy with our hemp steering committee. They are a group of, there's a leadership group, nine individuals. There's subcommittees that they have established, and we are working very closely with that steering committee, and did work very closely with the steering committee when we were making changes to our general permit.
Excuse me, Fred, I'm sorry to interrupt, but we're
running behind
here.
And I'm done.
Excellent.
And I'm done.
I mean,
so these are the contacts, and this is the information. And again, this information is all going to be available to all of you.
Excellent. Thank you very, very much. And I'm sure we'll have some questions that I hope we can get to. As a reminder, there is a forum. So for any questions that you have that we don't get to, you'll be able to post them there, and the panelists will be checking it to be able to provide answers. In my haste of time, I forgot to introduce myself, but just real briefly, my name's Erica Stark. I'm the Executive Director of the National Hemp Association, the Pennsylvania Hemp Industry Council, and I also serve on the Pennsylvania Hemp Steering Committee. So without further ado, we're going to move on to Zach Gihorski from NASDA. So Zach, please take it away.
Thank you. Erica, can you hear me okay?
Yes.
You forgot to mention that you're a rock star. You've been a wonderful partner to us. I'll be brief since there's so many wonderful panelists. First, I just want to take my opportunity to say thank you for letting NASDA participate in this. It has been a pleasure to work with Erica, Ed, and Deputy Fred. It's a pleasure to be with you, Sean, as well. A little bit about myself. I grew up on a farm in Southern New Jersey. I'm a Delaware Valley University graduate. I'm a former Department of Agriculture employee in Pennsylvania. I had the great honor to serve on the Fair Trail with Fred. Normally when we're together, we're having milkshakes, so this is a little bit different for us. I went to law school at Penn State. and I graduated in May and was fortunate enough to move down here to the Hill in DC to do agricultural policy, particularly on plant and pesticide, food systems and nutrition, and more recently climate change or climate adaptation work. The big things that you'll need to know from me is that representing all 54 secretaries, agriculture, and directors, we look at a macro level and we try to build consensus. 2020, the secretaries and directors of agriculture came together and set hemp as a tier 1 priority. That is just a testament to how important hemp is to the agricultural economy. You can go on our website and see a lot of our news and comments on that. One of the things I think is important to take away from 2020 was obviously COVID. COVID had tremendous impacts in many people's lives, including the policymaking process. Many state legislatures were unable to meet and pass laws that were required to do some of the things that they need to do at state level to do to get their USDA approved plans or to get their programs further along as they would like. Because of that, we had a tremendous amount of outreach from our members to work on extending the implementation of that final rule, as you heard Fred talk about. NASDA worked with the administration and asked for enforcement discretion, and ultimately we worked with the Hill to get the language included in the continuing resolution to provide that flexibility that our members needed to be successful. We did make a comment in the last comment period, both to the DEA comment, but then also to the IFR. The three main takeaways, and I'm not going to read to you our comment, but just for those here, is that NASDA supports a 1% negligence threshold. We are asking that they drop the DEA laboratory testing requirement and that they provide some flexibility for remediation before entering interstate commerce. Again, I just want to be brief. I'm happy to take questions at the end, but it is good to see everyone and thank you.
All right, thank you so much, Zach. Next up is Bill Richmond, the chief of USDA's hemp program. Bill, take it away.
All right, thank you, Erica, and we appreciate the invitation and the opportunity to get to spend some time with everyone here this afternoon. So my name is Bill Richmond. I'm the chief of the program at USDA, and we wanted just to give you a quick update on where we are with the rulemaking project, and then a quick update on where we are in terms of approval of state and tribal hemp production plans. So just a quick rewind. So back in October of last year, that's when we issued the interim final rule. This was, of course, the document that laid out all of the regulatory requirements for states and tribes on how they are to establish and administer their own hemp production programs. It explained what needed to be done in terms of licensing, sampling, testing, compliance, sharing of information, and all the other requirements that needed to be met. So following publication of that document, we opened up a public comment period for a few months. We received around 5,000 comments during the initial period. We then reopened the comment period again this fall for about a month. And our goal there was to really try to collect as much up-to-date information as we could from the 2020 season. We received just over about 1,000 additional comments. I wanted to point out that when we did reopen that comment period again, we tried to really point out those specific topics and subjects that we were seeking additional information on. So in the notice that we issued to reopen the comment period, we asked for specific data, specific insights from states and tribes and from individual growers around some specific topics like measurement of uncertainty, liquid chromatography factors, the 0.877, and the math around that. We asked for input around disposal, remediation, the negligence threshold, as Fred mentioned. Should it be 0.5 or should it be something a little bit higher? We asked for insight around interstate commerce. Should there be consistent requirements that everyone needs to meet in terms of how you label hemp as it moves across state lines? the always controversial 15-day harvest window. We asked for input on, if that is too short, which most everyone agrees that it is, what should it be and why? We asked for insight around, what to do with issues around immature plants like seedlings, microgreen facilities, cloning type facilities and nurseries, insight for hemp breeding and research, and all these different topics that we tried to really focus and narrow down the comments on, so we had the information that we needed to try to improve on some of the content in the interim funnel rule. So, like I said, we had incredible feedback to that reopened comment period, and I know a lot of folks listening in spent a lot of time on putting together comments for us, and we certainly appreciate it. So, since the comment period closed, we have been working frantically on trying to assemble a final rule. And so I'm happy to announce that we were able to get a first draft of the final rule over to the White House Office of Management and Budget last week. And so what that means basically is that's the formal handing over of the document, if you will, to the next stage of the review process. OMB then shares that document with the rest of our federal partners, like our friends over in EPA and in DEA and FDA, Small Business Administration. They're all able to review the draft document, provide feedback, suggest edits. We take all those edits together. We meet with all the different agencies, and we hash out our differences, and that's how we arrive at the final version of the final rule. So I think it's safe to say that we are still hopefully on track to issue a final rule in the early part of next year. I wanted to clarify for everybody that, of course, as we work through the review process, unintended issues certainly do arise, and given what's happening in this town around the change in administration right now, that certainly doesn't make it any easier for us. But rest assured that we're trying to move as quickly as we can to try to have a final rule out the early part of next year. So that's what's happened with the rule. Just really fast update on state and tribal hemp production plans. We continue to receive and review draft hemp production program documents, similar to the exact same process that we went through with the state of Pennsylvania. We continue to actively approve state and tribal hemp production plans. Once the final rule is issued, we anticipate that there will be some changes to the requirements that any state and tribe needs to incorporate into their plans. And so we are anticipating, of course, continuing to be able to review those plans as the requirements change in 2020-21. The other thing that we're doing is that we are overseeing the state hemp production programs for 3 states. Currently, we're working with growers in Mississippi, New Hampshire, and Hawaii to help administer their own hemp production programs and to issue licenses to those folks individually. So that's all I have for right now. Be very happy to answer any questions. Thank you.
Thank you very much. That was very informative, and it looks like there could be some good news on the horizon. So thank you. Next up, we have Sean Mitchell from the DEA. Sean, please take it away.
Hi, Erica. Thanks so much. And thanks to you and the Pennsylvania Department of Agriculture for the invite and the opportunity to present here. I've been engaged or have engaged roughly 24 state departments of agriculture and/or law enforcement or justice. And I know that there's several issues as it relates to DEA on this issue. And DEA is committed to being as transparent and upfront as possible. And we really appreciate the opportunity to speak with everyone today. I first want to, so my background as Chief of Intergovernmental Affairs, I know that sounds like a great DC title that says a lot and nothing at all. But my role is I'm the primary, I'd say, interlocutor or person responsible for engaging at the interagency and with state and local and industry and organizations on the hemp issue for DEA. I want to just note upfront and unequivocally that DEA wants to have the lightest possible footprint in the hemp space. I was Chief of Congressional Affairs when the Agriculture Improvement Act was passed. I was the guy negotiating with Senator McConnell and others' offices, and I can tell you that no one more than me understands congressional intent with respect to hemp and DEA, and that Congress wants DEA out of the hemp space. And again, that's why we're seeking to have the absolute lightest touch in there. So I think a lot of folks have asked clearly and have talked to me of why are you involved? And DEA is only involved in this issue as it relates to any substance coming from the cannabis sativa L plant that is greater than 0.3% delta 9 THC on a dry weight basis, and is therefore what a lot of people refer to as hot hemp, or as under federal law is indeed marijuana. That's where DEA is involved, and we try to be involved in no other place. And we clearly, recognize that USDA has complete authority, in the hemp space. With USDA, we've had they've been outstanding partners. I talk with Bill and Sonia and their colleagues probably once or twice a week. In my 25 years of federal government service, I haven't come across a greater group of folks to work with that are trying to navigate, a very, thorny issue. Again, in all things as it relates to USDA's IFR and now the final rule, DEA has sought to be as flexible, and as transparent as possible on everything related to hemp. The biggest issues, as I'm sure everyone, here watching is aware, as it relates to DEA, and I'm happy to take any tough questions you want afterwards, fall into several areas. The first being analytical labs. We've definitely received a lot of feedback, as I know USDA has as well, as to why labs need to be DEA registered. Quite frankly, I understand the frustration, but under federal law, those folks handling labs handling controlled substances need to be registered with the DEA. One thing that we are very, very aware of, and we've worked very closely with USDA on, is we understand that there's a current lack of capacity in DEA registered labs. I think when we first started working with USDA and we're trying to look at a baseline, Bill can correct me if I'm wrong, but there's roughly 44 labs that were DEA registered in 22 states, which we clearly understood that is nowhere near the capacity required for this rapidly growing industry. So we work closely with USDA to, expand the enforcement discretion that is in the IFR. And all I can say is we continue to understand that that is a major concern and continue to work with USDA with their final rule to make sure that DEA lab registration is not the long pole in the tent for the hemp industry and does not hold anyone back unnecessarily. The second issue, I think we heard loud and clear, and I think we're as big as proponents as other folks out there regarding destruction. As Fred mentioned, typically the only two ways for destruction, prior to USDA's policy guidance back in February, was you had to go to reverse distributor, which we clearly understand folks, already that had maybe a hot crop, they didn't want to have to pay to go to reverse distributor to get rid of it, and they had to be a DEA registrant to do so anyways. Another issue is the other way to do it was getting it to law enforcement. Being law enforcement ourselves, we clearly understand that state and local law enforcement doesn't have the resources and capacity to take custody of acres and acres of hemp. So DEA clearly, supports, USDA's policy option on the destruction. And we've also heard remediation come up, and we've also engaged them substantively on remediation. DEA clearly understands nothing will anger a grower more than knowing that through no fault of their own and trying to do the best they can, they were trying to grow hemp lower than 0.3% THC. And unfortunately, it's above 0.3%. We understand no one wants to lose their entire investment. So we worked really, really hard with USDA on potential remediation options. And then the final one that's been brought up as relates to our IFR on hemp is with typically the CBD extraction. And I'm sure there's going to be some questions on that, so I won't go into too much detail, but we are clearly understand, and this goes with both hemp farmers and the CBD extraction industry, that the 99.9% infinity of folks out there want to try to do the right thing. They want to understand the law, they want to follow the law, and they just want to know what's required of them so that they can make very important life-changing financial decisions. And DEA is absolutely committed to getting them that clarity and being as upfront and transparent as possible. And with that, I look forward to your questions. Thank you.
Thank you very much, Sean. And yes, you can rest assured there'll be a few. Okay, last but certainly not least, welcome Ed Messina from the Office of Pesticides from the EPA. Ed, take it away.
Great. Can you hear me and see my slides?
Yes.
All right. So thank you for having me. Really appreciate the opportunity to speak with everyone today. This is my second time in this 2 years of presenting at the Pennsylvania Hemp Summit. As Erica mentioned, I'm currently the acting director of the Office of Pesticide Programs. This is me last year presenting at the summit. I just torn my Achilles, but didn't stop me from coming to visit. And I appreciate the cameraman focusing on the video in the background to get the video of me wearing the boot for a while, but I'm all healed up and good to go. So now I get to present remotely. So talk a little bit about regulatory authorities. Basically, you've heard from USDA and their role, approving the plans, putting out rules. That's part of the Farm Bill that we're all operating under, the legislative authority. FDA has a role regulating products that are drugs and food, cosmetics. And EPA's role is to approve pesticides that can be used on hemp to address pest pressures. The other piece of that is when we are approving pesticides to address pest pressures from the applications that we receive from registrants who want those products approved, we need to address what are called tolerances. So what is the maximum amount of pesticide residue that will be allowed to remain on each treated food or product that is approved? And that is FFDCA is the statute that we operate under there. So we set the tolerances, and then FDA will actually enforce food tolerances for pesticide residues. So EPA has been very committed to approving pesticide registrations for use on hemp. Since December of 2019, we've approved around 50 products, some state requests, and then some federal registrations, about 49 registrations. There's a website at the bottom where you can see exactly where and which products have been approved. Nearly all of them have been the biopesticide products, and that's because we haven't yet set any tolerances for some of the conventional pesticides. So these pesticides actually don't require a tolerance because they're safe to use at any level in food. And so there's about 50 of those. But the pest pressures that these pesticides address include many issues that you may be dealing with: corn earworm, bollworm, leafhoppers, aphids, various diseases, mold, mildew, blight, rust, mites, nematodes, and of course, weed pressures. So if you consult our website, you can find the product that has been approved on a federal label to address pesticide registration for hemp. And again, we work with our state agencies as well. States can make special requests for local needs where they would like to have additional products available. We've worked with virtually all the states that have hemp production, and we've approved additional registrations in Kentucky and Indiana, and working on requests from other states as well to add additional products to the list for use by growers. And then on tolerances, one of the things we need to work on is making sure that tolerances are safe. We're working with USDA's grantee called IR4 to do studies on different conventional pesticides that will require tolerance set. So some of the science behind that is, how much of the pesticide is extracted after, and when you're growing the plant and when you're extracting the oils, how much of that pesticide comes along for the ride, and such, so that we can establish safe pesticide residues on the actual finished product when it leaves the farm gate. So we need to kind of do that sort of calculation and bridging analysis to make sure that anything we're approving at the farm gate is kind of for the varied uses of hemp that this crowd is very familiar with, taking that all into account as we conduct the science there. So here's a fun stop for more information on where you can go to find additional information on the EPA's approval of pesticides for hemp, our general pesticide page, how to register pesticides, and the list of pesticides that are registered on hemp, and also various test guidelines should you be interested in developing a product that can be used on hemp. So with that, I will stop sharing and take questions.
All right, thank you so very much. We've been given a few extra minutes, so we're gonna try to clip through some questions here. And I think I'd like to start with Sean. I think it's obvious that there's a gap in the regulatory framework with USDA's jurisdiction ending at the farm and FDA's jurisdiction over consumer products not being fully developed yet. So processors who are actually doing the extraction of the material are left in a kind of no man's land where they don't have protection of permits from USDA and they're not being regulated by FDA. We've been trying to push for USDA to be able to extend their jurisdiction to include processors like many states have, including Pennsylvania. But we understand that that's not something that they can do in rulemaking, that would require an act of legislation to implement that. But for now, I know that with the issuance of the DEA's rule and articles in the press stating that this is not a top priority, considering all the other considerations that DEA does need to concern itself with, that hemp processors aren't a major concern. But that's not all that terribly comforting if you're a hemp processor, because it's not even just the DEA. In certain states, we have seen state district attorneys and attorney generals sort of, interpret their own way this gap in regulation. What is your recommendation for hemp processors that want and need to stay on the right side of the law with the landscape the way it currently is, or what would be your ideal solution for protecting them?
Somehow I figured I'd be first. Yeah.
I'm sorry.
No, I'm ready to be stumped. I will kind of tiptoe around things because obviously, like USDA, we have the IFR while the comment period's closed, it's still out. What I can say is this is in the comments, and even before the comments, it's been very, very clear to DEA that industry and folks are clamoring. And like I said, they just want to understand what's required of them under the law, and they want to know so that they can follow the law. And they're looking for that clarity because obviously, there's financial and other considerations they need to take into account. What I can say is DEA is, I'm sure you've seen, I'm the guy that's always quoted the articles, obviously you'll never hear DEA say that we're not going to enforce any federal law, but we're very, very focused on the opioid epidemic, the amount of meth, and the Mexican cartels. We certainly understand the optic, which would be disastrous for DEA. And I can assure you that DEA, I think a lot of folks think the DEA agent's going to be swinging from a rope off the roof, through during the middle of a hemp or CBD extraction, when they get above 0.3% THC. And we clearly understand that would just be not a good thing. And so what I can say is we're looking at all kinds of policy options as part of our IFR. What I can tell folks is, this is not, it's not uncharted territory for DEA, like what we do with Big Pharma, where Big Pharma takes non-controlled raw materials and through the process of manufacturing gets to a controlled, product at the end of the pipeline. But during that manufacturing of that non-controlled end product, they've produced or manufactured controlled substances. They're required to be registered with DEA as a controlled substance manufacturer. So obviously, it's not necessarily unheard of for us or foreign territory, but we are looking at kinds of different options, and we clearly understand and are committed to making sure that industry understands what's expected of them under the law as soon as possible.
Okay. Do you feel that that is something that DEA could do on its own, or is there anything that, as an advocate, that you would say should require some legislative action to ensure that the protections are there?
As a civilian employee of the federal government, I can't advocate, but what I can say is that the options that we're looking at, to my knowledge, we have all the authorities we are required.
Okay, excellent.
Is that a good federal answer?
Yes, it is, but that's okay. So my other question for you is regarding D8, and the definition of D8 sort of, on the one hand, it said that cannabinoids that are synthesized are still considered controlled substances. And D8 is one of those weird things. It can be derived from CBD, and it can also be extracted directly from the plant. So can you provide us some clarity as to the legality of Delta 8 products?
So what I can tell you is as far as Delta 8, if it is derived from the plant-based cannabis sativa L, it's legal. And I can't really say too much more because of, the pending IFR, but, anything from the plant-based, is legal.
So that means if it's derived from CBD that was derived from the plant, it is still legal?
If the substance, any substance derived from the plant, cannabis sativa L, that has a Delta 9 THC on a dry weight basis, less than 0.3%, is legal under federal law. How's that?
Okay, so it doesn't matter that it's 2 chains below, so we're good. So people that are operating Delta 8 products are operating lawfully.
Let me just say, if anything that's below 0.3% Delta 9 THC on a dry weight basis is legal under federal law.
Excellent, and I think
for now, right now, yes,
we'll be happy to hear that. Okay, Bill, you're up. Can you talk? I just want to reiterate how wonderful it is for you guys to be here and participate in this way. It really is a wonderful opportunity for us to get to ask questions that sometimes are difficult to get to the right people to be able to ask. So again, we appreciate all of you being here. So Bill, you broke some news here that I don't think a lot of people knew about the rule being at OMB right now. So I'm wondering if, knowing what the major issues were primarily around the harvest window and the sampling, the negligence level, can you give us a sense of which of the issues that you've heard from the industry the most, outside of the processing permits, which I do understand would likely require legislative action? Which are the concerns that you're hearing from the industry the most? Do you have the authority to address in the rule versus what may need legislative authority to change?
Certainly, that's a great question, and I just first wanted to thank Sean. I mean, I think that's, that kind of insight coming from the DEA is incredibly valuable for the industry. And I will just echo, exactly what he said in terms of our partnership and our working relationship together. I mean, it doesn't get any better than that. And I want to make sure that everyone participating in this understands that DEA is trying to do everything they can to help the industry. And that's, I don't think it gets any more clear and transparent than what you've just seen. So I think the best way to foreshadow the content of the final rule is to look at what we put in the notice to reopen the comment period. And so we think these are generally the issues that we are able to change ourselves at the department level. And these are the things that we do not necessarily need congressional action to modify. And so really it's the topics that I had mentioned before when I ran through the notice. So a lot of the more technical issues around sampling, so how samples are collected, where samples are collected on the plant, how they are collected out in the field, the number of samples that are collected, the training that sampling agents undergo to make sure that the folks that are out there doing the sampling are doing it consistently and accurately across the different states and tribes. Some of the more technical issues when you get into when material actually arrives at the facility. So some of the conversion factors, some of the math around measurement of uncertainty, how to prepare samples, in terms of, grinding or removing stems and seeds, those types of requirements. Obviously the negligence threshold, something that we feel that we're able to amend on our own. Requirements around the 15 days is another example. Hopefully being able to provide some flexibilities for research facilities, for plants growing immature plants that may not ever even grow flowers. And so we're trying to hopefully build in some potential flexibilities for those types of facilities. I think that pretty much covers the list of those types of things that we think we're able to fix on our own.
And I think that we can then maybe deduce that we can expect to see some changes to those line items once we make when we get to see what the final rule says. And so thank you for that very much. We only have a few more minutes yet left. Could you please talk a little bit about what programs USDA may have available for the industry within your department that people can look to apply for or learn from?
Absolutely, yeah. And there are a lot of new and exciting programs coming out of the department here over the last year. And so one of the most exciting ones has to do with some of the work that's going on with the Agricultural Research Service. So they received pretty significant funding here over the last 2 years or so. And so they're doing a lot of really cool work around germplasm, around varietal research at a number of their research labs all across the country. Some other pretty interesting things that are going on have to do with insurance and other risk management products. So we offer several different varieties of crop insurance products to hemp producers. There's a whole farm revenue protection policy. There is a multi-peril crop insurance pilot program policy option that is out there, and I know that is available for Pennsylvania producers. There's some really interesting other options coming out under the nursery crop insurance program for the 2021 crop year. We have farm loan products available for beginning farmers, farm storage facilities, and all types of other hemp-related facilities. We have non-insured crop disaster assistance programs available. We have a wide range of conservation programs available under our EQIP, the Environmental Quality Incentive Program, the Conservation Stewardship Program, and a wide range of other programs available. The best place to look to get the whole overview of all the different products and tools that are available, take a look at farmers.gov/hemp, and you can see everything out there that's offered by the department.
Excellent. Thank you so much. And I honestly wish I had a session alone with each of you. But unfortunately, we are out of time at this point. I'm sorry I didn't get to the other questions or the audience questions, but I'll remind you that there is a forum for this session that you can type your questions in there and hopefully get some answers. I know you guys can't hear the audience, but I'm sure there is loud applause of gratitude for all of you taking the time to be here and sharing your insight. So before we go, I also need to take a quick moment to recognize our top level sponsors, Lancaster Farming, King's AgriSeed, PA Agricultural Business Development Center, and Air Products. So with that, again, thank you all for attending. Thank you to our fantastic panelists. There was really a lot of great information in a short amount of time. And I deeply appreciate each and every one of you being here. And I'm sure you'll all hear from me in the near future. So thanks again. And I just don't know what to say, but thank you.
Thanks for having us. Bye.
Appreciate it. Thank you.
Thank you.